On behalf of the Cape May County Chamber of Commerce, it's my pleasure and privilege to introduce this morning's webinar speaker, and that is Russell Lichtenstein, a partner at Cooper Levenson Attorneys at Law. And as a once great football coach said, Russell, time's yours.
Thank you, everybody, and good morning. I am an employment lawyer, and I also live in Cape May County, so the chamber is near and dear to my heart. And we thought we'd spend some time today talking about getting back to business here in New Jersey during COVID-19. Yeah, I'd like to say getting back to business after COVID-19, but that is not the reality. The reality is that we are going to be dealing with these issues for a significant period of time into the future. The length of that time is a matter of scientific debate, but it's all the more reason that we have to carefully consider the process of reopening our businesses and what it is that we can and should, and perhaps from a legal standpoint, must do. I have to give a disclaimer. I plan to spend probably a good part of today's session answering questions. I really can't provide legal advice without getting involved in specific factual scenarios. So I'm giving you kind of the broad outline of my best judgment based on the limited information that might be supplied in a question. And so we're going to start by so Nina, is that up?
Yes, you're looking good.
Okay, all right, let me get back to my first slide. So getting back to business during COVID-19, as I indicated, the first thing that we have to think about from a non-legal perspective is preparing for the return of staff. And in preparing for the return of staff, one of the critical issues, and it will depend on the nature of your business, is the guidance from Trenton and local government officials. Specifically, are you permitted to open? If you are permitted to open, what restrictions are you operating under? Are you still in the red zone, so to speak? Or are you like some of the restaurants going to have the ability to reopen for outside service on the 15th of June. The other thing that we have to do when we're bringing staff back is to understand the risks associated with our business. And once again, every business is different. You're going to have to perform what is known as a risk assessment to determine this issues that relate to the safety of both your customers, your clients, and your employees. A risk assessment, and once again, we're talking about risks associated with COVID-19 and related illnesses. A risk assessment involves taking appropriate steps to control the risk of exposure. There are things known as engineering controls, which involve, among other things, issues related to your ventilation system, making sure that you have appropriate ventilation, making sure that you speak with your HVAC contractors to make sure that your filters are in appropriate condition and operating appropriately for the size and nature of your business. You may also want to discuss with your HVAC contractor increasing ventilation rates to get more air movement inside of your business. Another engineering control is installing physical barriers. So for those of you who have had the courage to wander out and go to various places, you will see that there are, in most places, plexiglass barriers between employees and patrons or clients or customers. You're going to have to consider where and when and if those devices are necessary or appropriate. Another risk issue is requiring the utilization of personal protection equipment and training with respect to the use of masks and gloves and other PPE. In addition to engineering issues, we have to concern ourselves with administrative issues or management issues, how it is that we manage our businesses during COVID-19. All businesses, and these are things that have to be done or should be done before we try to flip the switch and open the business. Businesses should develop a set of no personal contact rules. Handshaking, hugging, closed or confined meeting spaces, other physical contact. We have to encourage a set of policies, develop and encourage a set of policies that involve not sharing personal items. So for instance, in a restaurant setting, you don't want people sharing pens. In an office setting, you don't want people sharing papers or computers or other workplace items to the extent that you have that ability. You need to reevaluate your floor plan. This obviously is of more concern to retail businesses as we get ready to reopen retail businesses than offices and professional businesses. Look around, see how your business is structured. Think about one-way only movement within your business to avoid close contact. If you've been to the supermarket lately, you will note that many supermarkets have tape on the floor asking people to stay 6 feet apart and indicating movement through various aisles. So you reduce the number of people that are coming in close proximity to one another during that time. With respect to the floor plan, you have to determine whether or not it is consistent with social distancing, and if not, what you can do to improve that condition. One of the first things that we did at my law firm, actually even before the governor began to enter his executive orders, was to eliminate common gathering areas. There are areas where both staff and attorneys would gather for lunch. We literally removed tables and chairs from those common areas and encouraged people not to gather in those areas, not to gather in the area where the coffee machines are. And I would encourage you to do the same. And once again, that's going to involve an assessment of your physical plan to determine where people tend to gather and to make arrangements to remove anything that is conducive to that gathering, and also to instruct your workforce of the importance of not gathering. And this is a very difficult, among the more difficult issues that we face during COVID-19, which is that among the reasons that people come to work is for the socialization aspect of work. And we are asking them to avoid contact with other employees, many of whom who have worked with you for a long time. Not an easy thing to do. In addition to doing the assessment, we need to establish cleaning rules for common equipment, copiers, fax machines, things of that nature that are frequently touched by many people. Limiting the number of employees in small spaces. And once again, just as an example, one of the things that we have done, and the way my office is set up, there is on the main level, a series of conference rooms. And those conference rooms are used for meetings and depositions and hearings and things of that nature. And one of the first things that we did was we removed probably at least half of the seating capacity in those rooms. So if you've ever been to my office, we have a couple large conference rooms with literally 14 chairs around them. We've removed 8 of those chairs. So when you sit down at that table, you are literally 6 to 8 feet from the person who is next closest to you. You have to think about breaking the 9 to 5. Now, that's not going to work in some businesses because they are typically 9 to 5 businesses. But as a business owner, you have to determine whether or not there's an ability to stagger schedules in order to keep people separated during the workday. You may also find, as I think we have, and a number of the other businesses we represent have found, that staggering schedules actually helps with productivity in terms of particularly big projects that can't get done between 9 to 5, and you're able to hand off work and have somebody who comes in at 3 and works until 8 or 9 at night. So consider staggering schedules in order to reduce the number of people that are in small spaces at the same time. Employers should be establishing requirements for employee sanitary practices, hand washing stations, the availability of hand sanitizer, other cleaning and disinfection practices. As a matter of law, employers are permitted to require employees to comply with sanitary practices, and you should develop a policy and a protocol for your staff to engage in that kind of conduct. And that has a couple of different benefits. I mean, the first benefit, obviously, is the actual avoidance of any possibility of an outbreak. The second benefit, and this may be as important as the first, is reassuring your employees that you, as a business owner, are doing everything in your ability to keep your businesses safe, and that you're taking the issues that relate to the outbreak and controlling the spread of COVID-19 as seriously as you can, while still trying to get people back to work. In addition, obviously, to preparing for the return of employees to the workplace, we have to start thinking about getting customers and clients back into our businesses. And a lot of the things that we talked about in terms of getting ready for staff to return obviously also apply to customers. And once again, customers and clients need to have some level of comfort in what you are doing as an employer to protect them from the outbreak from an outbreak or an infection related to COVID-19. We need to strike a balance as employers between public health and safety concerns and business functions and customer client service, which is not, it's easier said than done. You don't want to scare customers away on the one hand. On the other hand, you want to make certain that when a customer or client leaves your facility, they have a sense that you have taken the current global health pandemic seriously, and that you have done everything you can reasonably do to keep them safe. That may include requiring customers and clients to wear PPE when they enter your store. I mean, I have, and I'm sure that many of you have had the same experience. I have been in a place to pick up takeout, a number of different places where either the takeout system is set up at the door, or if you have to enter the building, there's a sign that essentially says, you know, those old signs that would say, no shoes, no shirt, no service. Now the signs say, no mask, no service. And you have to consider whether or not that is something that you want to do. To take another example from Cooper Levenson, and our office is not technically closed, although we have encouraged people to work from home consistent with the governor's executive order. But when people are in the office, they are required to wear masks when they are in common areas. They are permitted to remove the masks when they're in their own personal workspace. But when they are in the hallway, entering the building, At the copy machine, they're required to wear um, their masks. Likewise, we are going to require clients who enter the building to wear masks until they get to their destination. And then depending upon the reason that they're in the office, it might be appropriate for them to remove the mask, or it might not be. It's going to depend on the circumstances presented with respect to that matter. One of the issues you're going to have to deal with as an employer is handling the enforcement of the PPE rules. Let me just back up a little bit here. You know, I don't know if anybody's I don't know if anybody's on the in the webinar from a boardwalk-based business, but I heard a story from the Ocean City Boardwalk, where a business on the Ocean City Boardwalk that did takeout work had queued up lines for people to wait by putting X's separated by 6 or 8 feet on the boardwalk, and were asking people that when they were in line to wear masks. And some of the customers were very, very, very non-compliant. And the issue that that employer had was, what do we do with those non-compliant customers? And my answer, quite simply, was, you have the ability to refuse service. And if that's what you choose to do, you can enforce the PPE rules that way. I've talked about this before, but perception is as important as anything these days. And the question is, based on what you are doing, will your space be perceived by your clients and customers as safe during these very uncertain times? For instance, you know, how do you queue customers? How do you line them up at a checkout stand? How do you control their entry into your business? And do you need to establish occupancy controls and limits? Now, the government, the state, may answer that question for us going forward by limiting occupancy to certain retail establishments to a certain percentage of what occupancy used to be. You know, on those occasions when my wife tells me it's my turn to go to the grocery store, I notice that there is somebody literally at the front of the grocery store with a hand counter, counting the number of people that enter and then subtracting people that leave, so that they are controlling the number of people in that store. And you may have to give consideration to something, whether that's something that you want to do or not. You know, as a lawyer, one of the things that I am most concerned with in addressing issues that relate to COVID-19 is balancing what an employer's obligations are and an employee's rights are under the law with issues that relate to COVID-19. And it's moving too fast for me. The most significant piece of legislation that impacts our ability to address COVID-19 issues is the ADA, which I'll talk about in a little bit more detail, and also OSHA. So the ADA is the Americans with Disabilities Act. We're all familiar with that. The act prohibits discrimination against people because they have a disability. It also requires employers to engage in a proactive process to reasonably accommodate employees with disabilities. It also prohibits certain medical inquiries that are made of employees. It prohibits pre-employment medical testing and prohibits a number of other things relating to the gathering and dissemination of medical information relating to employees. OSHA is the Occupational Safety and Health Administration. OSHA has not played as dominant a role in this in COVID-19 issues as one would think, but essentially OSHA requirements mandate that employers maintain a workplace which is reasonably safe for employees. So let's talk about some of the specific legal issues that we are going to encounter as we begin to get back to work, with keeping everything that I've said in mind in terms of, first of all, making sure that your business is permitted under the various state and other authorities to reopen. So, can an employer ask an employee who's returning to work, or ask every employee who's returning to work, about whether or not they have been exposed to COVID-19? Before this pandemic, the answer might have been, well, that would be a medical inquiry, and that's prohibited by the Americans with Disabilities Act. However, in light of the nature of this illness, in light of the ease in which it has apparently spread, both the EEOC and federal government have made it clear that employers are permitted to ask employees about whether or not they have been exposed to COVID-19. Employers are entitled to ask employees whether or not they have any of the symptoms associated with COVID-19, or whether or not they live with somebody who has been diagnosed with COVID-19. Now, this may sound logical, but it is a departure from what the law typically requires or prohibits with respect to medical inquiries. Let me back up. One of the things that the ADA does require, and this is going to be important for all employers, that information relating to medical information, medical conditions, medical diagnoses that an employer comes into possession of remains confidential. There is, of course, a bit of a problem with that in the context of COVID-19, because an employer is going to want to let other employees know that they have been working with someone who the employer now knows has either been exposed to COVID-19 or, in the worst case scenario, has been diagnosed with COVID-19. And the way that employers are permitted to do that is simply by indicating, we believe that you have been exposed as a result of your contact with another employee, without identifying that employee, and then address the issue, and we'll talk about that in a minute, going forward in that manner. Who would have ever thought, 6 months ago, that employers would be asking employment lawyers whether or not they can take the temperature of employees as they enter the workplace? Well, that, of course, has become a big question. And the answer to that question is yes. And, for those of you that might consider taking the temperature of employees returning to the workplace, I would certainly recommend that you do away with any oral thermometers. That would make no sense at all, and invest in a few of those guns that are no contact devices that allow you to take temperatures of individuals re-entering the workplace. The science, however, indicates to us that not everybody with COVID-19 has a temperature, and not everybody with a temperature has COVID-19. So that is something that you need to consider as you are deciding how aggressively to monitor your workforce. Another question that we are asked frequently is, can we require employees to be tested for COVID-19 before they return to the workplace? And the answer is yes. But the practical problem is that the testing is not readily available. And so if you're going to require people to be tested for COVID-19 before they come back, you're going to have difficulty staffing up because those tests, particularly in our non-urban area, are not generally available. Same thing with requiring medical clearance documents. That is permissible in connection with COVID-19 exposure. But once again, it's going to be difficult from a practical standpoint to get medical clearance documents in light of the general unavailability of testing. Let me back up here. Another question that we get very often is, well, I have an employee who has, I don't know, emphysema or some other condition that lends itself to them being infected because of whatever that comorbidity is. They are more likely to develop COVID-19 than other members of the population. What can I do with respect to that employee? And the answer is that the mere fact that they are more susceptible to, that employee is more susceptible to the virus than others is not the basis to either not allow them to return to work or perhaps create other restrictions. Unless, and this is a legal term, unless they present a direct threat either to themselves or others in terms of their health and the health of other people in the workplace. And the direct threat analysis is one that requires a significant level of proof. So I would strongly urge you, if you are in a situation where you're concerned about an employee, not because you believe that that employee is infected or is living with somebody who's infected, but because they're 68 years old, they have emphysema and some other medical conditions that are typically viewed as conditions that make it easier for that employee to become infected. Don't do anything rash. Check with your employment law professional and figure out a path going forward. And so the next question that we often get is, what do you do with sick employees? Once again, and this is, I'm repeating myself here, but a departure from the typical requirements of the ADA and other anti-discrimination laws. There are inquiries that are permitted. Employers are entitled to ask employees about their symptoms, whether or not they've had any of these symptoms associated with COVID-19, whether or not they have been diagnosed with COVID-19, whether or not they are caring for somebody who has been diagnosed with COVID-19. Once again, that information should be focused on gathering the information the employer needs to make an appropriate decision about whether or not that employee should be allowed back in the workplace. And once again, that information needs to be maintained confidentially. And just as a sidebar, for those of you who have employees and maintain employee files, please keep in mind that the law has always required that medical information be kept separately from other information. So time and attendance records, performance evaluations, disciplines, accommodations, things like that would go in one file. Documents relating to medical leaves, notes from doctors about somebody missing time from work because of a serious health condition have to be kept separately in a separate file, and access to that file should be restricted to the HR professional or the owner of the business or somebody at a very high level in the business's organization. If an employee is sick in connection with COVID-19, and shouldn't be in the workplace, does that employee get paid, or do they go out without being paid? And the answer to that question is really going to be a function of whether or not that employee, based on their length of employment and their use of sick leave, has any accumulated, accrued, and unused paid time off available to them under either New Jersey's sick leave law, under a collective bargaining agreement, or under whatever policy or practice the employer has. They're absent that entitlement, there is no obligation of an employer who decides to send an employee home because they believe that that employee is sick and that that employee's illness potentially threatens the health and safety of other employees and customers. There's no obligation, absent the existence of that paid sick leave, to pay that employee once they're taken out of the workforce. One of the last things we ever want to talk about in connection with any employment situation is laying off people. We want to do whatever we can to keep people employed. There are other incentives, obviously, these days in terms of stimulus money to keep people employed. But you may find yourself in a situation where your business just doesn't need the number of people that it had before this pandemic took hold of us. And this advice really doesn't change whether the reason for the layoffs relate to COVID-19 or some other business issues. The point is this: you need to develop a non-discriminatory layoff matrix. And what does that mean? It means that when you make a decision to lay people off, you have to make certain that the manner in which that process is applied is not discriminatory. And obviously, the easiest way to do a layoff and the most unassailable way to do a layoff is to do it by an objective measurement that nobody can argue with: seniority. We've all, those of us that are involved in business have. Did I just do something bad?
Seems like maybe you stopped sharing your screen. There you go.
Is it back? Okay.
It's back. You might want to put it into slideshow mode.
How's that? There
you go. All set.
Those of us in business have all heard of, the concept of last in, first out. And that concept merely means that when we're trying to adjust the size of our workforce that requires us to let people go, we figure out who came in last and they leave first. The reality, however, is that many employers who I talk to, big employers who have large-scale layoffs, will say to me, well, wait a minute. Some of my best performers were the people that were most recently brought to the company. And those people that have been around a while, quote, the older workers, end quote, aren't really doing as much of a job as we would like. The problem with exceptions to a layoff matrix is that they tend to lead to litigation. So what I would tell you to do, and once again, this is not a commercial for employment lawyers, but if you're an employer that decides that you need to have a layoff and you're going to be letting go, more than a few people, is to have somebody carefully look at the process and the matrix meaning what the decision-making criteria is to conduct that layoff. There are all kinds of traps in the layoff world, such as something called a forced evaluation. So for instance, if I run a business John Kelly and I run a business and we have 30 employees, and we decide we only want 20 employees, and we decide we're going to have an evaluation of these employees done, and whoever scores the lowest, the 10 people at the bottom, are going to be let go. Well, of course, we are conducting that evaluation for the sole purpose of getting rid of employees. So guess who's going to be scoring the lowest? Those people that we would like to get rid of. And there are all kinds of problems that are attendant to that. We see many claims of discrimination, many claims of retaliatory conduct relating to layoffs that are not conducted using a bulletproof, non-discriminatory layoff matrix. I can't see all of you, but if I were to ask you, how many of you have heard from employees when you're talking to them about coming back to work, I'd rather collect unemployment, or I'm just not comfortable coming back to the workplace? I would see many hands. The hard reality is being more comfortable getting paid and not working while collecting unemployment is not the basis to return, is not a basis not to return to the workplace. Each person that collects unemployment is required on a weekly basis to verify, to certify, to swear that that there's no work available for them. So if you're reaching out to an employee and saying to that employee, we put you on the schedule for beginning next week. We are permitted by the government to reopen. We're reopening to the extent that we're permitted to reopen, and we need you back at work. Please show up at 9 o'clock on Monday. And their response is, well, I'm only making $100 less collecting unemployment than I would if I came to work, so I'd rather not work. And then the question from the employer to me is, well, what do we do? And the answer to, and without being too draconian here, the answer to me is pretty simple, and that is, number one, you tell that employee that it is your obligation as an employer to provide appropriate information to the Department of Labor and Workforce Development Division of Unemployment Insurance. And that would include, obviously, the fact that you had offered employment to an employee indicating that it was work available and that they declined, number one. Number two, and then if they don't show up for work, that they'll be handled consistent with whatever your time and attendance policy is, meaning that they may both lose their job and lose their ability to collect unemployment. Same thing with the I'm just not comfortable coming back to work comment, although that is a little more nuanced. Obviously, all of us that pay any attention to the science have a level of concern about our health and returning to places where other people are present because of the possibility of exposure. But that generalized concern is not the basis not to return to work. And so the comments that I made about the people that would rather collect unemployment would generally apply. However, and this is the nuanced part, to the extent that someone has an actual diagnosed, medically verified anxiety condition that they're being treated by a healthcare provider, that employee may be entitled to leave under the Family Medical Leave Act, assuming that that the employer is covered by the Family Medical Leave Act, which only applies to employers with 50 or more employees, and B, assuming that they provide the information necessary to qualify under the Family Medical Leave Act. One of the first things that happened legislation-wise at the outbreak of COVID-19 was the enactment of the Families First Coronavirus Response Act, FFCRA. And that act provides benefits for people who are either quarantined, actually quarantined because they are infected, that they, and also provides protection for people that are caring with individuals who have been diagnosed, and also with respect to people who are required to care for children as a result of the closure of schools or the unavailability of daycare providers. And there is an entitlement to paid leave for employees under certain circumstances. First of all, employees that are subject to a governmental quarantine or isolation order, and those words have legal meanings, quarantine and isolation order. So I'm not talking about somebody that is in the general population and is not infected and is not specifically subject to quarantine or an isolation order. You know, for the vast majority of people, this doesn't apply. But if an employee is subject to a governmental quarantine or isolation order, they're going to be entitled to paid leave. If they're advised by a healthcare provider to self-quarantine related to COVID-19, they're going to be entitled to certain paid leave. And if they are experiencing COVID-19 symptoms and seeking medical diagnosis by a medical professional. So that last bullet point is in the situation where somebody has not yet been diagnosed, but they have symptoms consistent with COVID-19 and they are in the process of seeking medical attention in connection with that. Under these circumstances, under the three circumstances that I've indicated, those employees are entitled to be receive paid leave up to a maximum of $511 a day or $5,110 in the aggregate over a 2-week period. This obviously is calculated based on a 5-day-a-week work week. And so the per day limitation is multiplied by 10. There's also paid leave for employees that are calculated at a different rate who are required to care for an individual subject to an order related to a quarantine or isolation order or self-quarantine. Those employees are limited, however, to 2/3 of the regular pay, up to a maximum of $200 a day or $2,000 in the aggregate for 2 weeks. The FFCRA also provides for paid leave for employees that are required to care for a child whose school is closed or daycare unavailable. And the limitation there is still that 2/3 rate, but now instead of a 2-week limitation, it's a 10-week period. And the employer pays for this leave. However, employers are entitled to a tax credit for the entire amount of any required payments under FERCA. And the tax credit includes credit for the employer's share of certain required payroll taxes. And also, the employer is not subject to their portion of Social Security tax on what is paid out to employees who are receiving sick pay or family leave wages. And also, this time period does not count towards the time that somebody would be entitled to under the provisions of the Family Medical Leave Act, and it applies to all employers. So there's not that 50 employee minimum. What is it that we need to do to get back to business? And this list could go on and on and on, but there are many sub points under each of these major headings that we've talked about during our time together. Obviously, you want to train employees. You want to train employees not only with respect to your expectations for their own hygienic health and safety, but also for how you want customers and clients to be handled in the space that you do your business in. what your expectations are in terms of the way customers and clients will conduct themselves, what requirements you have with respect to them. You want to assess your space. We talked a while ago about engineering issues, about management issues, about the way the space is set up, making sure that your air handling system is up to par in terms of what you need to move air safely around your business. You want to educate your customers and clients with respect to everything that you're doing to increase their comfort in returning to your business, in returning as customers, as clients, and helping us move ahead in this most difficult time. So that was my prepared part, and now I guess we're going to move into the Q&A.
I don't see any questions in the chat. Do you have anything?
Nope, no raised hands so far. So everybody, if you do have any questions for Russell, I think, he did a great job of covering lots of stuff. So maybe he was clear enough that everybody's all good, but just in case, you can go ahead and type your questions in the chat box using the icon at the bottom of your screen, or you can go ahead and raise your hand on Zoom. You'll find that in the Participants tab. If you're calling in on a touch-tone phone, you can dial *9 to be put in the queue to ask a question.
Well, while people may be doing that, I had just a thought and maybe a question. I think, Russell, your reference to perception with respect to employees and customers is really big. I think common sense will go a long way in that, because people will notice, I think, right away if you're making an effort or not. For instance, I've been into some businesses of late that you really could tell they're working hard to keep people safe, and then the ones that are not, you can really tell. I was in a takeout establishment recently. They had no organization for coming in and going out. Employees had masks on, some weren't on properly, and you could just notice like right away. And I think it can really help or hurt business if you just don't take some steps to at least have some common sense measures in place.
Yeah, look, I believe that the perception of your clients and customers is extremely important, because if I want to go pick up a pizza and I'm going to go to the pizza parlor where the employees are doing everything I think is reasonably appropriate for their safety and my safety, and not to the pizza parlor where half of the employees are not wearing masks. The employees are gathering behind the counter, chatting, and things like that. I mean, it's not that I'm a germaphobe. It's and look, we all want to give ourselves the best chance to avoid becoming infected, and the way we do that is by keeping our eyes open and seeing what other businesses are doing. And it's part of customer service. It's part of what you want to do to build your brand.
Absolutely. We do have a couple questions coming in, Russell. One from Franklin. Are there any requirements or guidelines specifically around disinfection, decontamination of workplace prior to opening?
There are no legal requirements. There are certainly recommendations that are readily available on the CDC website. I think it's cdc.gov. I would recommend that you check it out, and it's going to change based on the nature of your business. And keep in mind that what we do know from the science is that the overwhelming cause of exposure relates not to touching surfaces, but person-to-person contact. And the way we avoid that the best is by social distancing and using personal protective equipment, and also washing our hands and using hand sanitizer. So there's no law that requires washing your hands and using hand sanitizer. There are certainly significant recommendations. And once again, I would encourage you all to check out the CDC website to keep up to date on what their recommendations are.
Absolutely. The CDC website is great. And also the Chamber has gone to great lengths to put information on our website for all the different specific types of businesses from trusted sources on how to open up properly with a whole bunch of guidelines and guidance in that area. CapeMayCountyChamber.com/reopencmc. It's under the business resources main menu on CapeMayCountyChamber.com for all different types of businesses. So we also have a question from Tracy. Could you, Russell, go over the employer tax responsibilities of family medical leave?
So I'm not sure I understand the question, but let me give it a shot. Under the Families First Coronavirus Relief Act, if employers pay employees as a result of them being quarantined or self-quarantined or caring for somebody, or in connection with the reduced amount that their employees are entitled to in the event that they can't come to work because childcare is closed or schools are closed, the employer is entitled to a tax credit for everything that they pay that employee. So virtually for the entire economic consequence of paying that, they're entitled to a tax credit. Your business accountant should be aware of that. So not only is the amount that you physically pay the employee you're entitled to a tax credit for that. You're also entitled to a tax credit for your portion of the taxes, Medicare tax, Social Security taxes, and also entitled to a credit to the extent that you pay the employees' healthcare premiums during the period of time that they are not working.
I see Tracy shaking her head and she says, thank you. I think you had answered her question. We have a couple more chat questions, but I want to go to Nina, who has a raised hand. Nina, you want to go ahead with that question?
Yep, so our question comes from Brittany, and Brittany, I'm unmuting you, so you should be able to go ahead and unmute at this point and ask your question if you had still wanted to ask it.
Yes, thanks, Nina. Hi, Russell. How are you?
Hi, Brittany. Brittany and I know each other.
Yeah, pretty well. So
She's
I had a question. I had a question about, I know we talked a little bit about employers dealing with employees who said, I'd rather collect unemployment. And when at the peak of the pandemic, a lot of employers were allowing employees to work from home that normally would never do so. What are your thoughts on employees who, instead of saying, I'd rather collect unemployment, are saying, I'm in high risk to get COVID or to transmit it to someone else. I don't have any flare-ups and it doesn't affect my ability to do my job. However, my doctor has told me I should work from home. And there's no, like, it's sort of indefinite, and the business really isn't set up for these individuals to be working from home indefinitely.
Okay, so and that's an excellent question. The reality here is that that certain businesses, you can work from home. Certain businesses you can't. I mean, I represent a meat packing company, and you can't pack meat remotely. You have to be on the line. The mere fact that during the height of the pandemic, that employers were doing whatever they could to keep employees on the payroll is not going to jeopardize an employer's ability, assuming that this is a business that is permitted by the government to reopen, by insisting on that employee returning to work as scheduled. The fact that they believe that they are at high risk of contracting COVID is not enough. Once again, that would, Brittany, that would go into the part of the direct direct threat analysis. And I think that, if you have emphysema or some other underlying condition which makes it more likely that you would contract COVID-19, that in and of itself does not give you the ability to say, I'm not going to work from home. I'm not going to come into the office. I'm willing to work from home. And the employer is going to have to make a decision on how to treat that employee's request. And one of the things that employers will tell me, and I get it, is that they not only have to consider what that employee's request is, but they have to consider how responding to that request is going to impact their ability to respond to other similar requests. So, I think that you have to listen carefully to an employee who is telling you that they don't want to come back to work. Make sure that there is nothing in there that might signal to you that they have an actual disability for which they need an accommodation, or that they already have some approved family medical leave, for instance, for intermittent leave for one condition or another, and make an assessment. But at the end of the day, assuming that that there's no legal issues, an employer is entitled to make that decision. It may not be the most popular decision, and it may make that employer seem a bit more aggressive than the employer might want to seem. But those are the kinds of situations where the person where the buck stops, the owner or manager of the employment setting is going to have to make a tough decision. And I don't believe, based on the facts that you set out, that an employer under those circumstances is required, if it doesn't work for them, to allow somebody to work from home.
Got it. Thank you so much. It's great seeing you.
Good seeing you.
Okay, I think maybe we have time for another question or two. This one's with regard to daycare for an employee. I guess if an employer was aware that an employee's daycare, childcare was closed, when that daycare reopens, are they required to come back to work?
I'm not going to be a lawyer in answering this question. I'm going to answer it by saying one word: yes. So an employee is no longer entitled to be away from work once the daycare is reopened. One of the other things, and this is kind of a sidelight to that question, one of the things that you quickly realize when you begin to read this legislation and see what our state and federal lawmakers come up with is the fact that sometimes they don't think things through all the way. So, for instance, one of the things that we as employers are going to have to deal with is this. We all know the schools closed early, right? I mean, everybody knows the school's been out since, I don't know, March, whatever it is. But schools are typically over by this time of year, more or less, right? I mean, schools are done for the regular school term, and kids are out of school for the summer. And I suspect that employers are going to be struggling with the notion that employees are saying, well, I don't have anybody to watch my kids anymore. And my response to that is, well, what were your plans in January before COVID-19 about how you were going to handle your children during the summer? That is obviously not something that Congress thought of when they were dealing with the Families First Coronavirus Relief Act. But my response would be, look, you knew that school was going to be out at the end of the school term. I would assume that you would have made arrangements for care for your children. We need you back at work. You need to make arrangements, and if you don't, we'll have to talk about separating our relationship. Or you can tolerate it. The problem is that if you run a business that's dependent upon employees, you're going to be struggling.
Okay, one final one again with regard to underlying health conditions and returning to work. I guess is there a list somewhere that people can refer to that lists the underlying conditions that are maybe allowable under the FFCRA if they don't want to return to work, and can they refuse to return to work due to some of these reasons, whether it's, like you said, maybe they have emphysema or like obesity or anything like that?
The fact that you have a medical condition that might increase your risk to become infected with COVID-19 does not provide the basis under the Family First Coronavirus Relief Act or any other provision of law to not return to work. And so, because if it did, then I don't know what the statistics are these days, but if obesity, for instance, was a condition, we in America are not doing well in terms of the percentage of the population that's considered medically to be obese. There'd be nobody at work. So having comorbidities, which created an increased chance for your contracting COVID-19, in and of themselves do not provide the basis to avoid returning to work. And look, I mean, we did away with involuntary servitude hundreds and hundreds of years ago. You can't force an employee to come back to work. You as an employer can make a tough decision by saying either you're going to accommodate that person's request and deal with whatever the consequences of that are, or tell that person, listen, this is what we need you to do. We understand that you're not comfortable in doing that. And as a result of that, we're going to have to separate our employment with you and move on. I mean, it would seem to me that all of you who are employers are going to be facing those kinds of decisions on a regular basis as we move forward. Because as I indicated at the beginning of this presentation, I would love to have been delivering this webinar at a point in time where Corona-19 was over. We are now into the post-Corona-19 phase, and we got to deal with the issues in the rearview mirror, as opposed to dealing with them looking forward and being concerned, if you're listening to this, the science community, about what's going to happen in the fall. So we're going to have to be dealing with these issues for a long time to come.
Okay. Well, I think that does it for questions. I am seeing a lot of show of appreciation, Russell, from the chat, and certainly on behalf of the Chamber, we thank you and Cooper Levenson for your time today and all you've done for the Chamber over the years. Just remind everyone that the slides and the recording will be shared after the event. We'll email that to everyone, and we always post them on our YouTube channel too. You can search Cape May County Chamber of Commerce on YouTube and see all of the webinars we've conducted, the important webinars over the days and weeks here leading up to today. And just a reminder, next Thursday, we have a webinar on opening summer businesses, strategies and plannings for that. And then our monthly meeting on the 18th of June, the following Thursday from there. So that'll wrap it up for today. Again, thank you for everyone for participating. And again, Russell and Cooper Levenson for conducting this great webinar. And we look forward to seeing everyone's faces next time. So thanks, everybody. Have a great day.
Thank everybody. See ya.